Hi everyone, it's James from Community Legal Centres Queensland here. Welcome to another one of our webinars. This one, so you want to be a migration agent, a bit of a 101 for those of you looking to work in that space. Before I hand over to our presenters, can I acknowledge the traditional owners of the lands on which we're gathering electronically? And I know that Rob will also acknowledge traditional owners. Can I thank everyone for joining us? We are hoping to record a copy of this webinar and make it available to you. We sent around a copy of the PowerPoints to people who'd registered this morning, but you should also be able to access a copy of that document from the handouts section on the control panel there. And you can follow those along as notes, and we'll email around another copy later on. There are a couple of ways that you can ask questions as this presentation goes on. We prefer you to hold your questions over until the end, if that's okay. You can ask questions either by typing a question into the questions box on the control panel there, or by pressing that button that looks like a hand on your control panel. We'll be able to unmute your microphone and be able to ask a question. I think it might be best though, there's plenty of content to get through today, so I might ask you to hold those questions over until the end. That's my housekeeping stuff. Can I introduce Bruce and Rob from the Refugee and Immigration Legal Service, who I'm sure are very capable of introducing themselves, but Rails is a specialist community legal centre here in Queensland helping refugees, asylum seekers and others with immigration law problems. And they're going to give us, in an hour, everything that we need to know about working as a migration agent or working in this immigration law field. I might hand over to Rob to start with. Just excuse us as we swap chairs.
Thanks, James. Hi, everybody. I'll do some of the presentation and we'll take over then Mead and Bruce, so we'll be swapping chairs as we go along. So first, okay, right. So wherever we are in Australia, of course, we're on Aboriginal land, and first law of this land is Aboriginal law. For 40,000 years, maybe many, many more than Captain Cook took a look at this sacred South land, put a flag in the sand at Possession Island. A few years later, a fleet of tall ships sailed into Sydney with a mob of convicts. Britain planted their law after Philip Governor created a colony, ignored the tribal law. In 1901, Constitution, colonies became a nation, democracy creation, Australia celebration. That's a little, I've been challenged to do some raps and puns, and that was the first one. So we acknowledge first people and what we're going to be covering in this session. And will be a little bit about Rails, then about becoming a registered migration agent, an overview of migration law, and something about the migration program. Then we'll go into key areas, and Bruce will look at some refugee stuff, and we'll do family reunion, family violence, cancellations, and a little bit on some other areas, overstay students, 457 visas, and if we have time, a very quick look at refugee clients and interpreters and networking, and then some questions. First of all, Rails, we've been going for about 37 years, so we've been around quite a long time, and there's like a copy of our pamphlet. So we do a lot of things in terms of regions. I don't know how many people are here from the regions or locally in Brisbane, but we do have local advice sessions at Rails in West End. We've got regional phone advice, we've got family law employment advice, asylum seeker support for boat arrivals, as you can see there, protection visa, immigration, domestic violence clinic, family reunion clinics, and outreach in the greater Brisbane area. And we also do community education, that's where that rap came from. So becoming a migration agent, that's covered by the Migration Agents Registration Authority, Part 3 of the Migration Act. So the Office of MARA, O-M-A-R, Migration Agent Registration Authority, used to be just MARA, but it then became the Office of MARA because the government wanted to take a little bit more control of it, so it became OMARA, which was the Irish version of MARA. Anyway, that's number 1 or 2. So the function, so MARA deals with registration, monitors the conduct of RMAs, Registered Migration Agents, investigates complaints about immigration assistance and takes disciplinary action. So to become an agent, you just go to the website and click on the Become an Agent, and that's all you really need to do. You must be, as you can see here, an Australian citizen or a New Zealander with a special visa, special category visa, be a fit and proper person, hold either a prescribed course or prescribed qualification. So the course is Graduate Certificate in Migration Law. There's a few unis that does that. Griffiths here in Queensland does it, but there's some others as well. Or the prescribed qualification is being having a practicing certificate. Note that MARA is actually loosening its strings, and that lawyers possibly soon will not need to become migration agents and might be able to do migration law, might give migration advice without becoming registered, as I understand it. MARA is definitely loosening the strings also on the continuing professional development, which they control at the moment. So costs, as you can see, it's not much for a not-for-profit. For a for-profit agent, it's $1,760, and repeat registration each year. There's those figures, $105, $1,595. You also need to have a compulsory library, which is a Legend.com subscription, and that's, as you can see, $420 and $345 for secondary licenses, and that's a really good online system where you can just dart around the place, lots of links, and it's got all the legislation, the regulations, all the instructions, the policies, and also historical stuff as well. You have to do your CPD, another cost, and of course your lawyer's practicing certificate, graduate certificate. Now, a role of migration agent similar to that of a lawyer. You need to be aware that if you give immigration assistance and you're not registered, it's a criminal penalty. It's a very serious offence, and giving immigration assistance means using your knowledge or experience in migration procedure to assist a visa applicant. Now, lawyers can give immigration legal assistance at the moment without being registered. That's fairly limited. It's sort of at the end of the stage of visa application and decision, where court proceedings where it's not about preparing a visa application or review application. Migration agent responsibilities. There's a code of conduct which outlines the professional responsibilities that mirrors in some way the solicitor's rules, but there's also some slight differences here and there. But that's something that you need to have and be across. You have to undertake 10 points of CPDs. Now, the MARA Regulation E is easing, as I said, but also in terms of lawyers, now you just need to do your lawyer CPD, 10 points, and not migration agent CPD. So that's loosened it considerably for lawyers. You still obviously need to do your compulsory units there. You need to have a library, subscription costs for the library. You have to advise your professional indemnity insurance of the expansion of coverage if you do become a migration agent, because there's added risks. I'm not sure whether that will increase premium or not. And you also need to get visa entitlement verification online. That's to check visa applicants' conditions and visas. So I'll give now just a quick overview of migration law. So it's covered by the Migration Act and the Migration Regulations, and of course there's case law, there's ministerial directions, Gazette notices, and PAMS, that's the Procedure Advice Manual, and the Ministerial Series Instructions. Their policy, it's guidance for the department, but of course it's not law, and you can challenge that when you need. The structure of the Migration Act, fairly quickly, I'll just won't really go through these, just to say that there's it's a huge monster, and there's lots of different parts to it. Parts that you will be interested in will be Part 2, Part 4A, review decisions, review protection visa decisions, fast track review, we'll talk about that, judicial review, restrictions on court proceedings. Bruce will maybe mention a little bit about that, but basically that's just the overall structure. I don't know if I'm going too fast or slow. Maybe James, you can kick me if I am going either of those. The regulations, there's different parts of the regulations. Once again, it's a huge document, and you need to be aware of all the little twists and turns that are in the migration regulations. A major part of the regulations and being a migration agent and applying for visas are the schedules to the regulations. So Schedule 1 outlines the classes of visas, and Schedule 2 the subclasses of visas. So you need to, your client needs to satisfy the criteria in those schedules that are outlined there. So there's also Schedule 3, which is some criteria for unlawful non-citizens and bridging visa holders. That's if you are unlawful, you know, there are restrictions on whether or not you can apply, and some limited cases you can apply. Schedule 4, public interest criteria. There are health and character criteria, security, that sort of thing. So they're within every visa. Special return criteria is about if you've been to Australia before and run foul of immigration law, there will be some restrictions on when you can return. Visa conditions are Schedule 8 are very important too, so things like whether you can put in another application, whether you can work, all that sort of thing is in visa conditions. So for example, you might have a 8503 which says no further stay, which means you can't really apply for any other visa application, any other visa except a protection visa, usually. And then there's other migration regulations, other schedules to the regulations, and they can concern the points test and a whole lot of other things which we don't really do much of. Student visas we don't do much of. Business skills, once again, we don't do all that much of. You can see Schedule 8 visa conditions, you do need to know those. Now when you're looking at visas, and visas are particular numbers, this little table here is quite interesting because it gives you the type of visa you'll have. So like a bridging visa, you could have an 050 bridging visa, that's the unlawful bridging visa. 101 permanent visas, there's permanent visas available from overseas. For example, the partner visa, permanent visa is a 100. The 200s are refugee and humanitarian visas available from overseas, so you could get 202, 204, we'll talk a little about that, or 200. The 300s are temporary visas available from overseas which allow holders to apply for permanent visa once they arrive in Australia. So for example, 309 engagement, temporary spouse, provisional spouse visa. The 400s, temporary residence visas, the 457 is one of those, which is well known around the place. 500 students, 600 visitors and medical. 700s are the humanitarian concern temporary protection. We'll talk a little bit about these. These are the infamous, for some, TPVs, temporary protection visas. So they would be like a 785, and there's also what's called the SHEV, which is the Safe Haven Enterprise Visa, and that's not a Chevrolet, that's a Chev. The 800 are permanent visas available in Australia, and so that would be, for example, 820 is a spouse visa, that you can apply. An 801 permanent visa available in Australia. So that's sort of an interesting little table, so that you know if clients come to you, they've got a particular visa, you sort of can see sort of where they fit, or where that visa fits within the structure. And if you're going to try and give options for other visas, you can sort of see, well, you sort of know where you're heading. Now, in terms of schedules, Schedule 2 criteria, so you need to satisfy Schedule 1, which is the class of the visas, and Schedule 2, they're all the same sort of set out as you've got here in front of your screen, which are primary criteria for the primary applicant at time of application and time of decision. So criteria has to be satisfied at the time of application and time of decision. So you need to be looking now and forwards as well. And secondary criteria are for secondary applicants. So would normally be the family unit of the principal applicant, and they also have to satisfy criteria at time of application decision. Then there's other parts of the schedule, so about the circumstances applicable to the grant, when the visa is in effect, when it actually gets into effect, the conditions on the visa, and the way of giving evidence, if it's a stamp and a passport, that sort of thing. Now this little slide here too is also an important one too, because it's a pathway to visas, and basically under the Act you have Section 29 where the Minister may grant a non-citizen a visa. Visas may be temporary or permanent, and there's classes which may be subscribed, Schedule 1 and 2, which we've talked about. 45 must apply for a class of visa. 46, and these regulations of what 207 and Schedule 1, what a valid visa application in. And it's also important to know about bars on valid applications, because there are some bars if people have been refused or cancelled before, whether they've arrived unauthorised, whether they've had a safe third country that they've been to in terms of protection applications. So review, of course, is very important. Under the Act, there's a few deadlines there that, once again, if you're a migration agent, you need to be totally across. Often they're 21 days. Note there's 7 days in detention. If you're in detention, you have less time to apply for some reviews. There's offshore applications that's got 70 days plus 20. Notification is normally 7 days. 5. So when letters are posted, you normally can have 7 days for that. Yeah. And there's for the character cancellations and general cancellations, there's different sort of review times. The Immigration Assessment Authority, which Bruce will talk about fast track reviews, 21 days, judicial review, 35 days. Cost orders need to be aware, of course, if people put in applications which are vexatious to lawyers that are frivolous or vexatious, so you can have cost orders against you. Now, just a very quick overview of the Permanent Migration Program, just to give a little bit of a bird's eye view of what we're looking at. So you've got the humanitarian migration in sky blue there. It's at the moment around just over nearly 14,000, rising to 18,750. That, as you know, it's a highly political area, and that increases or not, depending on what's happening. Family migration is around 60,000. These are last year's figures. And skilled migration around 130,000. But also, no temporary visas. You've got over 1 million temporary visas in 2015, and plus 0.7 million New Zealand visa holders that are here. So the migration program obviously is massive. There's sort of different streams. A lot of the family are partner visas. The skilled are a mixture of different visas, and that's an immigration department slide you've got there. The purpose of it is to build the economy and to shape society and to reunite family and support the economy. So this slide here just gives you an overview of the type of visas, the main sort of visas that you might deal with in terms of permanent visas. So under the Refugee Humanitarian Program, we have the 200 to 204, which is the offshore refugee visas. Then there's immediate family of some refugee and especially humanitarian program holders. So I'll talk a little bit about that. Bruce will talk about the refugee visas. The protection visas onshore, there's the PV 866, so that's to remember the 866 is a permanent visa. The temporary protection visas, the TPV and the Chev 785, 790. So then you can have family and migration, there's partner, fiancé, dependents, orphan relatives. A lot of those are the ones, say, from the remaining relative, age dependent and parents, particularly have got huge waiting lists. Not uncommon to have a waiting list of 30 to even 50 years in some of these, which is bizarre, but there's a thing called cap and queue, so that the minister can cap how many visas are given each year. So say for parents maybe 500 a year, or and there's maybe 40,000 in the queue already from a long way back. So there's a contributory parent, which is the rich parent visa, which is a lot quicker, but you need around 40,000 or more to apply for that. And then there's the skilled business visas, which are quite well. Once again, that's a huge program, but you need good English, high demand, and high skills. Now, I think. Yeah, so just in terms of the humanitarian visas, and then should I, do you want to go into that? Or, yeah, start from here. I'll just finish here. So these are the refugee humanitarian visas, and yes, I'll leave it to Bruce to take over from here.
Good. Okay. Hello, everyone. One of the reasons we wanted to speak about the refugee and humanitarian visas, not just because it's a central area of our work, but also because increasingly people are being resettled into the regions. So while we're geographically located in Brisbane, and we try to service the regions through outreach programs and through telephone advice, we do suspect that there might be an increasing demand on regional CLCs to, at the very least, help people to access services such as ours. So with these visas that are on your screen at the moment, hopefully, you'll notice a distinction between the offshore and the onshore ones. So people who've been resettled through Australia's Humanitarian Program will have the subclass 200, the subclass 200 and somethings, and those who are granted their visa onshore will be in the 800s, the 866, or the temporary protection visa holders 785 or 790. So the SHEV, the Safe Haven Enterprise Visa, was brought into effect to encourage those people who've arrived in Australia by boat, usually without a visa, but who are owed protection, to move into the regions to contribute there in order to demonstrate their suitability for permanent residency in Australia. So again, we suspect that there might be SHEV holders who are coming to regional CLCs looking for advice. When immigration is assessing whether someone in Australia meets the definition of a refugee, this is the test that they apply. So it's simple to start with. They're outside their home country and they hold a well-founded fear of being persecuted or seriously harmed if they return to their home country. The motivation for those who would do them that harm is one of those 5 set out on the fingers of the hand: race, nationality, religion, political opinion, whether real or imputed, and or membership of particular social groups. I don't intend to spend a lot of time on these definitions. They're there in your slides. We'll just talk about some of the key things if people come to you and you're trying to figure out whether they have any prospect of being successful in an application for protection in Australia. One thing to be noted is that with recent changes to Australia's immigration legislation, the Refugee Convention definition is no longer referred to in the Migration Act. Now it's all been codified. It's defined in different sections of the Act. Effectively, the test remains the same as far as we know until the courts tell us otherwise. So you can see there, we've bolded key elements of it. The key thing is that a generalised fear of harm, such as from a civil war where it's not specific to an individual, is usually not going to be enough for them to be recognised as a refugee. There has to be someone motivated to harm them for one of those 5 convention reasons. Otherwise, immigration will view it as generalised violence and consider that Australia doesn't owe protection obligations. In addition to that refugee test, there's also what's called complementary protection, which recognises all of Australia's other international obligations. So we're a signatory to the Convention Against Torture, for example. So if someone has a real chance of being tortured on their return to a home country, whether it is for a Refugees Convention reason or not. They might fall under the complementary protection criteria. This test is usually not necessary. Someone who's owed protection will usually fit within the Refugees Convention, but it is there. It accounts for maybe up to 5% of people who are owed protection. This is just to keep you or make you aware of the process that people have to go through when they are applying for protection in Australia. So in comparison to other visa application fees, it's quite modest, $35 for a family unit. Doesn't matter how many members are in that, so long as it's parents and dependent children. They have to undergo biometrics, or rather they have to provide biometrics, that is fingerprints and digital photographs. They have to undergo medicals as part of their visa application, have to go through security assessments. It's quite a long drawn out process. People often ask about timeframes. I'd say minimum 6 months unless immigration takes a particular interest in a case. Anything 12 months is not unusual. So while their protection claims are being assessed, people remain in the community, usually on a bridging visa, but perhaps they still have a substantive visa that continues for that time. Often they'll be given permission to work, but that's not guaranteed, so they may also need financial assistance and may need to get advice about what other services they could contact. Similarly, if someone is unsuccessful with the department and they seek merits review of that decision through the AAT, the timeframes for the AAT are over 12 months for review of a protection visa application. So again, these are, even before a visa is granted, these are people who are going to be in the community for a long time, and many of them will be needing advice and assistance at various stages through this process. Basically, the whole onus on proving a protection claim is on the applicant, and there is also a strong impetus or a strong preference on the part of the department that applicants provide all of the details of their claims at the time of application. So there is provision in the Act for a decision maker to draw a negative inference with regard to credibility of a claim if it's not raised initially and is just brought up subsequently, either at interview or after an interview or on review. So when people are coming to advice, we always make sure that we impress upon them the need for them to raise all of the elements of their claim early, preferably at the time of application. The other significant one there is Section 91W, establishing identity. Immigration have a massive focus on identity at this time. A lot of people who've arrived in Australia with a visa usually will not have a problem establishing their identity because they'll be carrying a passport and will have identity documents from their home country. For those who've arrived by boat, that's certainly not always the case. At this stage though, because our boat arrivals have been in the country for so long and getting advice and assistance, most of those are well aware of the need to get those identity documents and have taken steps to do so. This is those groups of people, the ones who've arrived by boat without a visa to enter Australia. So important to always keep in mind the distinction between those who arrive by plane and can apply, with a visa. There are those who arrive by plane without, but for those who have a visa, they can apply for permanent protection in Australia. Those who've arrived without a visa can only apply for temporary protection at this time. They also do not get the option of having their applications reviewed at the AAT. Instead, they go through a fast-track process through the Immigration Assessment Authority, which is a review on the papers. They will not get an opportunity to have a hearing. They will usually not get an opportunity to contribute to that process at all. So if applicants are coming with decision letters saying you're a boat arrival, your primary application has been refused by the Department of Immigration, we've now referred it on to the IAA. Usually a visa applicant will not have to do anything for that process to go through. However, they will have the opportunity to contribute to it if they think that there are exceptional circumstances and new information should be considered. further on that. That's just some of the demographics of people in the community now who might be needing help with these processes. We have been told the Minister's lifted the application bar for almost all of these people now, so everyone is in the process of having their claims assessed. If anyone does come with a letter saying, I don't understand what this means, we encourage you to refer them to us or to other service providers, because immigration has made clear to us that there will be penalties for people who don't engage with this process in a timely manner now, notwithstanding that immigration has barred them from entering into the process for the last number of years. Now they're saying if they don't engage and don't lodge, there will be penalties. Again, on the fast track review, no hearing. Applicants will usually, Applicants will usually only have 21 days from the time of the primary decision to get new information or to respond to that primary decision to the IAA. Critically important, the IAA won't consider information provided outside of that time frame under usual circumstances. So that 21 days is in our list of critical times that was on that earlier slide. And again, the limitations on this review process, the IAA will only consider new information in exceptional circumstances. My view is when in doubt, put the new information in and let the IAA decide whether these circumstances are exceptional. Now, if people are successful in their TPV or SHEV applications, just some simple information about how they work. What people can access is effectively the same. What people can't access, that is family reunion, usually travel outside of Australia, and any pathway to citizenship is the same. What differs is the time frame. So TPV is the shorter visa, 3 years. SHEV is up to 5 years. And the TPV holder can only apply for another temporary protection visa, whether it is a TPV or a SHEV. The idea of the SHEV in its policy was that if people could demonstrate their contribution to the community, that they might have a pathway to other visas. So if they live in, not live, but if they work or study in a regional area for 3.5 of the 5 years, or they accumulate 3.5 years of work or study in a regional area, then they can look at what other visas they might apply for. If an applicant can only apply for another TPV or SHEV, then their protection claims will be assessed again. So we haven't got to that stage yet, but as you might imagine, that's going to cause a lot of anxiety for people going through that process. There's going to be a lot of uncertainty given that country information, the circumstances in their home countries, very likely to have changed during that time, and they will have varying amounts of knowledge about how that's going to affect them if they were to return. Okay, so we wait to see how this will play out. Effectively, if people are able to do 3.5 years, whether themselves or a member of their family unit, being employed in a regional area or attending full-time study in a regional area or a combination of the two, then that will open up to them other visa options. And again, the onus will be on the visa applicant to demonstrate these things. So if people are moving around a lot, it's really important to impress upon them the need to keep records of all of their work and study, because immigration won't be establishing that for them. And here's what we have at the moment in terms of the range of visas for which they might be able to apply. All of this is a long way off. We wait to see how it works out, whether this list is added to or subtracted from. But as Rob was talking about before, the schedules to the migration regulations set out what the criteria are for each of these. So if people are seeking detailed advice on what their options might be, this is where we would start and look at whether any of them apply to their circumstances. Now, most asylum seekers, I would hope, have got some information or advice about whether they're going to be applying for TPV or SHEV at this stage. unless there's a good reason for someone not to leave a metropolitan area, it appears that the SHEV is the more attractive option for almost everyone. So there are some people who really need to access services in metropolitan areas that just aren't available to them outside. And there is a lot of concern amongst asylum seekers that if they give an undertaking as part of their SHEV application that they intend to live, work / study outside of metropolitan areas and then they're unable to meet that undertaking, that somehow immigration will penalise them or draw a negative inference about their genuineness. So where clients are in doubt and are fearful, then there may be very good reasons for them to apply for a TPV rather than a SHEV. Again, what we find that people might be seeking advice about, often it is at the refusal stage, so whether it's primary refusal or IAA refusal, they'll bring decision records, etc., and say, what are my options now? What are my timeframes? When do I have to do things? And critically, who will help me to do them? Rob's talked about the limitations even on lawyers through the visa application and the merits review stage. By the time it gets to judicial review, lawyers are freed up to give immigration legal advice and assistance, but we recognise the limitations on many in terms of trying to assess merits of what is very limited scope for judicial review of migration decisions. So it is quite a specialist area, and in large part general advice is limited to easier review options. For example, you now have the option to seek ministerial intervention in your case or to seek judicial review at the Federal Circuit Court. This is the time frame. You have 35 days in which to lodge an application to the Federal Circuit Court. I can't assist you with that because I don't have the necessary knowledge to assess whether your case has any merit. But this is the address for the nearest registry to you, and they might be able to point you in the direction of some help. Genuinely, for a lot of people, that's the extent of the advice and assistance that can be given. Rails established a project pretty soon after the withdrawal of public funding for legal assistance for unauthorised maritime arrivals. Funded by the community, we have a lawyer who supervises / coordinates a whole bunch of pro bono support that we get from the legal community here in Brisbane and the greater southeast. We've been helping people to articulate their claims in a written statement which they attach to their visa applications. It goes off to immigration for assessment of whether they're owed protection or not. You might have seen in the news recently the changes to immigration's processing, where they're now giving 60 days for people to lodge valid applications or potentially be penalised. Previously, if asylum seekers had engaged with a pro bono service such as ours, and there are parallel ones all around Australia, then that had been enough for them to get extensions of time in which to prepare their application. There's big long waiting lists for these services. They're all volunteers, they're free of charge, they're not publicly funded. So immigration had previously had a policy of saying, yep, we understand the limitations that you're working under and we'll make allowance for that. That has now gone by the by, and applicants or prospective applicants are expected to comply with immigration's timeframes, whether they get legal assistance or not. So effectively they get to choose between having financial assistance, access to Medicare, permission to work, or waiting for a lawyer to help them with their substandard claims for protection. Excuse me. Might get back to Rob just because my voice is giving out.
Okay, so we have on our Rails website some fact sheets around the TPV SHEV applying for protection, so that's on the Rails website. We also, one of the other resources we have is a guide to refugee family reunion. So if you have a person come to you and they're a refugee, but they've been split up from their family because of conflict, and they're wanting to sponsor them or propose them to come to Australia, then this guide here that we've developed is an excellent resource to do that. So basically, this is for people who are refugees from overseas, so on the 200 to 204 visa, or on a 866 visa, refugee visa, protection visa, which is someone who's come authorised, as Bruce talked about. So they came as a visitor or a student or something, and something went wrong in their country, and so they've applied for protection visa on shore. So these people can apply for family reunion under the Humanitarian Program or the Family Migration Program, as you see on the slide. Now, the advantages of applying for a, say, spouse visa under the Humanitarian Program is that there's no cost, and also that the person gets they'll get a refugee type visa, humanitarian visa, rather than a spouse visa as such, so they'll be eligible for some support and they won't have to wait for Centrelink assistance when they arrive, whereas if they applied under the partner visa, under the green section there, the Family Migration Program, they have to, there's significant application fees around $7,000 these days, plus if you've got any dependents. So someone comes in and they want to bring their family over, which has been split by conflict. You can suggest perhaps on the Humanitarian Program what you need to be aware of is that the 200 to 204, they've got a high chance, and mainly it's the immediate family, which is spouse and dependent children, or if you're under 18 here as a refugee in Australia, then you can propose your parents under the Humanitarian Program. So obviously there's time limits too. If someone comes in, they're under 18 and soon going to turn 18, then you need to act very quickly. For people on 866s, or if they're former unauthorised maritime arrivals, former boat arrivals, they get the lowest priority. So basically they won't get an application, say if they put in for their spouse under the Humanitarian Program, because there's so many applications. Once again, there's a huge waiting list. So those that will get a visa under that Humanitarian Program will be the offshore refugees, people who've got their refugee visa from offshore. The people on SHEVs and TPVs, they can't propose family reunion because it's a temporary visa. And as we see, if for other family reunion, if people can't fit in with the humanitarian, people can apply under the Humanitarian Program. If there's a really special case, you may be able to sneak it in. A special case, it's not your immediate family, you may have a chance, but it's pretty tricky. Otherwise, you go under the Family Migration Program, and in some cases that may be a better option, but it's pretty tricky. And of course, as I mentioned before, the parent and the remaining, some of those timelines are really for making an application, getting a decision, many years. The only other one I think to be aware of is the orphan relative under 18 under the Family Migration Program. In terms of time limits, you need to be aware if someone's got an orphan relative overseas, and maybe the parents and family have been killed in the war, in the conflict. That application has to come in before they turn 18, the person overseas. So that's a pretty critical time that you need to be aware of. Or another limitation that should be made aware of is a person of 205, 204 visa holder, woman at risk. This is a woman who's come on a refugee humanitarian visa. She's got that visa because she's a woman, and because she's under threat, because she's a woman, and she's got no male to protect her. So it's often that's a single woman, and then she gets a 204 visa. If she finds her, if she has a spouse or fiance afterwards and finds out that that person's alive, she can't propose sponsor that person within 5 years if she hasn't told immigration about their relationship. So just need to be very, very aware of that. So that would be, if she got the woman at risk, which is you've got no male protection, but if in fact you did have a spouse or a male to protect you, then you wouldn't have got the 204 visa. So that's why that limitation is there. The other limitation, just for people generally, in terms of spouses, is you can only sponsor no more than 2 in a lifetime, and they must be 5 years apart, although there's some compelling circumstances if there's a partner dies or abandoned children or long-term relationship. Just in terms of the family reunion, there's the application forms that would need to be filled in. And often we'll just get the clients to do all that. We just don't have the resources to help people. We do help people with immediate family applications when we can, but there's a whole lot of other people who come here as refugees, really want to try and bring their family over, and getting an application in is something that at least they can do and try, but the demand is really high. We do have a lot of advice to give around that. And as I mentioned, TPV shareholders can't apply because they're not permanent visas. Family violence. So this is in terms of if a person who has obtained a visa and they're in a married or de facto relationship, they normally have to wait 2 years before they can obtain permanent residency, but there's 3 exceptions to that. And one is domestic and family violence, the other is child of the relationship, or if the sponsoring partner has died. So there's a list here of the types of visas that can engage these exceptions. So you've got that, the partner, the DV, family violence exemption, and the child exemption. So there's a whole lot of different subclasses of visas that will enable those exceptions to apply. There's family violence.
Yeah, just in the interest of time,
yep.
It's important to be aware of this area, in my view, and to be aware that Rails is funded to do casework, so to support people who might be relying on these family violence provisions. So in the event that someone presents to a CLC and says, I'm on a provisional partner visa, my husband or wife is threatening to withdraw sponsorship unless whatever the case might be, or just that our relationship is failing, we do encourage you to refer these clients to us, because it's not unusual, in my experience, for private migration agents or registered migration agents generally to be unaware of the details of these provisions, and we've had many clients who've been incorrectly advised. But if they do, if people are not permanent residents, if they've been sponsored to travel to Australia by a spouse or partner, can be same-sex, can be de facto, can be legal marriage, and they're wondering what their options are, please refer to Rails for some detailed advice and potentially assistance.
Yes, indeed. So people have to notify a change of circumstances, if their relationship has ended or they change address, that sort of thing. And they also, as well as proving domestic violence, have to prove that it's a genuine, or was a genuine relationship at the start until the relationship broke up because of domestic violence. And this is just a shot of the flow of a prospective marriage visa through to from offshore 300 visa, and onshore you would get a temporary partner visa, which is 820 for 2 years, and then an 801, your permanent visa after 2 years, if the relationship is still going, but if it's broken up within those 2 years for domestic violence or those other 2 issues, child and death, then permanent residence still can be obtained by the applicant. And yes, Rails does a lot of work on this, and there's a referral form on our website.
Yep, on the website.
Yes.
We do ask that you fill that referral form in, though. It really helps with our intake, assessing the urgency and other issues that we need to be aware of. So if you can get reasonably full instructions from a client when you're doing a referral to us, much appreciated. The other area we've seen massive increase in is cancellation, particularly under character provisions. So the Minister has a broad discretion to cancel visas because people are of poor character. The character test got tightened up a couple of years ago, and the number of cancellations has increased enormously. So a lot of people, whether in detention, whether it's criminal or immigration detention, or they may be in the community, are getting notices of intention to cancel visas, or are being notified that their visa has been cancelled as they approach parole dates. We have a kit on our website which we've tried to put into plain English so that hopefully people can help themselves. So between us and the Prisoners Legal Service, we try to provide advice, information to people in these circumstances, but we have very, very limited capacity to assist. Usually people will be told in their letter from immigration whether they are considering cancelling, that is, we think you might fail the character test, or it's just a mandatory cancellation because you do fail the character test. And then they'll be given timeframes in which they can ask for a reconsideration or a revocation of those. So again, with cancellations, immigration's usually pretty good with giving timeframes, but those timeframes are very tight. So it's not unusual for people to be coming with only a few days to a week's notice of when they have to get information in. As a first step, even if you choose to refer them to ourselves or to prisoners, we have the cancellation kit on the website, and we encourage you to get that to them as soon as possible so that they're not delayed in preparing any response that they might do themselves. I think we can go through cancellation just as we're out of time. So,
okay. So there's other general cancellation. If people give incorrect information, there's under Section 116 and Section 109. And visas can be cancelled basically anywhere before the person enters, or in immigration clearance, or whether they're here, or when they leave Australia. So very quickly, other types of cases that might come through your door as a migration agent. People who are overstayers, they're now unlawful. We need to talk about any visa possibilities onshore or offshore, getting bridging visas to make arrangements to leave. Students not fulfilling their visa conditions, about attending passing courses or working beyond 20 hours per week that they're allowed, or changing study institutions. People working with no work conditions on visas. Employers exploiting visa holders. 457 visas. Sponsors not complying with visa obligations about pay, accommodation, visa holders changing employers. There's a whole lot of other possibilities that we give some advice on, but we certainly don't have a huge caseload on that because we just don't have the resources in our legal service, which employs, I think, 6 solicitors and many volunteers. So very quickly, because we've only got a couple of minutes, this rest bit, you can have a look at this on the on your slides. It's basically about communication, just being aware of, in terms of with refugees, the trauma that they're going to face, the fact that that can really affect how they're going to present to you and how to deliver information and make statements. You need to build trust. You need to a lot more time with people often. And just be aware that you need to explain things and gradually build that trust. And the people will have come from different cultural perspectives. They may not trust people in authority at all. That their credibility, the AAT, the guidelines on credibility, accept that there could be trauma, and that people will be, this may affect the way they put their statements in and when they put them in, and it also depends really on the person's their own characteristics, whether how much trauma will affect them. With interpreters, just be careful. Sometimes people who can answer very simple questions may need an interpreter. They may need to come from, be aware that an interpreter from a rival ethnic group, political group may not be appropriate. Male or female interpreter for a female client may always or often be necessary. Communities are very small often, and so you might need to get an interpreter from outside Queensland for a very small group of people, because they think it's going to get spread. And although interpreters have ethical requirements to be confidential, it's not always. People don't think that that's followed up. So just be aware. You can look at those. I don't think we've got time for this. We've probably got a few questions. Just check with people about their understanding of your questions and the advice given, so you get them to talk back to you, tell back to you what they understand you're saying is probably the best tip there. There's contacts for interpreters. There's some resources there on the website, on the PowerPoint, and in terms of networks, we're always keen to develop and build our networks. We have many networks here in Brisbane area, and we've done a lot of work out in the regions too. So we're also keen where there are areas where there's private migration agents who could assist us, because and there's no, say, CLC or then we'd be really keen for people to link in with us. Say sometimes we have conflicts where we need to bring in other people. We're the only legal centre at the moment doing all this general immigration work. So I think it's probably, we've gone pretty tight, so James is going to see whether or not there's questions or if there is anybody still listening, which I hope there is.
Terrific. Thank you, Rob and Bruce. Lots in that presentation. I apologise, it looks like there were a few sound issues at various stages, so I apologise for that. A reminder that you can ask questions by typing a question into the questions box or pressing that button that looks like a hand, and we can unmute your microphone and then you'll be able to speak. One of the questions that's come through, Bruce, are you funded to run AAT appeals as well?
Some, limited, yeah. So we were previously funded through the IAAS scheme to run AAT appeals for protection visa applicants. That's no longer the case. Part of that policy, or rather reflective of that policy, that people should be putting all of their claims in at the outset and not relying on raising new claims at the AAT. So we do still run some, but our capacity to do so is much more limited than it once was.
We are running pretty close to time, and I think I'm not sure that we've got many more questions coming through. Can I ask, Bruce, you talked about the family violence referral form. Can I ask what kind of evidence or supporting documents it would be helpful for other workers to have pulled together before sending a client to you that might support that piece of work?
Yep, so in addition to any identity documents that the client would have so that we can establish who they are and to do those VIVO checks to confirm their visa status, if there's been any police involvement or any involvement by the DV services, if the client has any letters from immigration, particularly recent ones that need responding to, if we can get copies of those at the outset, it just saves us a lot of time and saves the client a lot of anxiety trying to get those documents to us.
Thank you. Rob, you mentioned before a movement towards solicitors not needing to be registered with OMARA or being registered migration agents, I guess. There's a question here just asking if you could elaborate on what looks like happening in that space.
Yes, so there was this review, and what they're saying is that you know, lawyers have their own registration practicing certificate, CPD, and they're all should be able to regulate themselves rather than have MARA as an overarching body. And there's you know, often can be some conflicts between being registered as a migration agent and as a having a practicing certificate. So basically, it looks like that MARA will pull out of regulating lawyers for migration work. That's my understanding. They certainly started pulling back a little bit in terms of allowing the CPD, lawyers' CPD to be used as migration agent CPD. So I think that's your understanding, isn't it?
That's the intention,
yeah.
But at the moment it would require a change to the Act for those offences where you have to be a registered migration agent in order to provide assistance. So until we see the changes to the Act, I think it's likely that the regulation will remain with, will continue with the dual regulation of the profession.
And I might take this as a final question that's come through from one of our participants, guys. For those people that are migration agents, how can they assist, volunteer with Rails, or get involved in the unrepresented asylum seeker project?
A few different ways. Certainly they can contact us if they're in the southeast of Queensland, and we can talk to them about their availability to help clients with their statements about their claims for protection. We also partner with organisations that help clients to fill in their application forms, which are substantial. documents and need a lot of assistance. And if you are a registered migration agent, that might be a better use of your qualifications, because there are a lot of people in the community trying to help asylum seekers to do those tasks, but who need some supervision and some guidance from time to time. So we can help connect you with other organisations if you prefer to do that more administrative task, or if you want to do statements, we can help with that. We are in Brisbane and soon to be in Logan, so we're encouraging people, even those who might be on the Gold Coast or in the Greater Logan area and don't want to travel in towards the CBD, we can hopefully accommodate you soon also.
Great note to finish up on. It's great to have people who are participating so supportive of this work. Can I, on behalf of those people who are clapping and cheering wildly at computer screens across the country, thank both Bruce and Rob for a presentation that had a lot of content, but also provided some really practical steps on how we might be able to do more work in this area, given the substantial needs out there in the community. It's great to see some messages of thanks coming through on the through the chat function as well. Thanks everybody for participating. Sorry if you had problems with the sound or the vision, but we will send around some information shortly. Thanks for participating, and all the best.